appeal from the quarters, Your Lordship. Your Lordship, if it is not listed on Monday, Your Lordship, they will be agreeing to your Tuesday has been fixed to evict them from the quarters.
But your writ petition must have been dismissed.
Yes, Your Lordship.
Then there is no urgency. Your writ petition has been dismissed by the High Court.
Yes, Your Lordship. I don't get appeal, Your Lordship.
We understand that the plea which you are taking must have been considered by the learned single judge.
Yes, Your
And
Lordship.
single judge was not satisfied. According to you, give your slip, we will see. All right.
Obliged, Your Lordship.
कितने नंबर
1770.
देखिए मेमो और ऑर्डर्स आइटम नंबर 1 the delay of 3 days in filing the CMPL application due to my illness. I could not appear on that date when it was listed. The WA was listed for arbitration. Notice is to the private party there. Notice is to go. There is a delay. And there is some directions that
So when your appeal was dismissed for default.
Default 7/10/2023. The 22 minute I filed after just 3 days thereafter. On 1 month and 3 days. Due to my illness, madam, because on that date I am suffering from gastric, acute gastric.
Who is for the other side?
The private party, there's a notice to go.
If you notice.
Madam. Of like.
Item number 2.
My one date may fixed madam because the fixer is old money about 1975 years. The date may fixed after just after notice matter may listed.
This is appeal after
By Monday I will file repeats, madam.
4 weeks. This is matter of 4 weeks. Item number 2.
Item number 2, I am appearing for on behalf of Mr. Mahanti, my lords. My lords, I just pray for this matter to be coming on next week, my lords. That's some defect, my lordship. The certified copy and the SR not made, my lordship.
So remove your defect.
My lords, by today,
Effective.
Yes, ma'am.
That the
Certified copy not filed.
certified copy not filed in what?
in the registration application, ma'am.
So the same appeal is not filed the certificate of this court's order.
We are ignoring that. So we can ignore that. All right, remove the defects of
My lords.
the defects as pointed out by the stamp reporter be removed within 1 week. List this matter under appropriate hearing on 2 weeks.
Item number 3. My lord, I have filed an IA in the judgment, wherein my lord has given a direction that the schedule should be as per the 2019 notification schedule. But the judgment was on 14/5 and the trial was on 14/5/2024.
14/5.
My lord.
And
But we had already given the schedule in the 21/10/2023 regarding the counseling and NOC. And but we have stick to the decision of this honorable court that it will be in time. And we have given the schedule. Schedule is I have given that. And that we will stick to that. And we will get the admission as per the date fixed 30th September of the INC for the admissions. That is what I want to bring a notice of the honorable court. Because this is deviation to my lord's direction.
no, what is the deviation?
Deviation is 2019, the schedule which has been given. That is, we have to do everything by July
Yes.
23. But that we could do because it is delayed already. The process should have started from July itself, from 2023, which we did in September 2023, my lord. And after the judgment, we have to comply with this, with everything. Now we are complying the order of the Honorable Court. In scheduled time, we will finish everything. So that's why I want to bring to the notice that we have deviated from that, could not be strictly followed. As the
No,
judgment.
no, after 14/5/2024, are you going to deviate
No, my lord,
on any point?
my lord.
Then what for you have filed this I?
No, my lord, the schedule which is given in the judgment, that differs from this schedule which are given in September.
Oh, given in September.
That's 2023. For this 2024-25, the schedule which was given in September, that was not as per the 2019 notification schedule.
So you did not bring that to our notice.
Yes, that
All
was
right.
where is that? That is page 19 of the judgment, my lord.
No, no. Where is your schedule?
Schedule is annexure. IA annexure.
Annexes at page 7.
Annexure A, my lord. Page 7.
Page 7.
Yes, my lord.
That can be done, madam.
Yes, ma'am. Yes, ma'am. That's what. That's I want to be.
Surprised that this was not even there in public domain when the hearing was going on, so. But anyways, so if they want to stick to this and.
We want to stick to that, and the next page is the INC's notification regarding admission. Page 8.
Where is the judgment?
Judgment, my lord, I have not given this is the judgment. Shall I get it, my lord?
All right, we will pass appropriate order.
Yes,
You will
sir.
see the file and
Yes, over Bobulation.
ये नंबर इनको dispose of कर देना और release कर देना. Yes. Yes, sir.
Item number 184, this is a matter of contempt. Since 2017, we have complied the direction of this honorable court. 184 item. My other friend who is appearing for the petitioner, I am for the alleged contempt now. So both the contempt can be dropped, madam. Obliged.
It is stated on the part that the court's order, violation of which has been alleged in the against contempt application has been complied with. Contempt proceeding stands dropped. Yes.
Personal appearance was directed earlier. That matter, that item number 480 onwards, it will report matter.
How many cases?
13 matters.
The personal appearance is there in some of the cases.
For the 490, that may be.
Mr. Das. I have received your representation, the resolution of the members of the bar. I am considering that. And the counters shall be inaugurated on 1st. All right. I'll consider extending that, but to a reasonable time, not the time which you are seeking, but I'll do something.
Can you do something?
All right.
You can understand my predicament.
No, this is not your predicament. As a chief justice, I have to understand the difficulties which the lawyers may face, the entire institution may face.
Exactly, my lord.
I am considering that.
I'm grateful, my lord.
That I intend to defer that for 15 days. And in the meantime, I'll make arrangements for this thing, training or acquaintances.
List. The list, Lordship, my learned friend said that list, in fact, we received at 10:30 p.m. So this is a
List of what?
That is this particular list.
List is a cause list, eh?
This contempt list.
Oh, contempt list. Oh, this contempt list.
Others were asked. No, entire list.
Entire list.
Entire list.
Why?
It in fact came at 10:25. My associate was there in office yesterday. It was raining. So in any case,
The website is also down till
Oh.
10:30. It was down. So we could not
Maybe.
check the list or the virtual.
Technical problems.
आजकल जो 400
so entire.
So what is the entire case is probably something else. Happened something. So 10:30 inside the server is down. That is your lordship.
No, Mr. So far these cases are concerned. I had instructed the registry to notify these cases on last Tuesday. So these cases were notified with stipulation that they will be listed today on Friday. This notice was there. This notice with a request to the learned counsel to inform the court as to cases in which the orders have been complied with. So this was done a few days back. And therefore these matters have been listed.
Suddenly getting the list at 10:25.
Suddenly, so
I did not know, my lord. My associate also did not tell me. She was not aware of this.
we will see, these contempt matters are unnecessarily pending for last, say, 12 years, 13 years.
That's correct.
So why should they remain pending? That is the area of concern.
The problem is, my lord, there are certain matters you have to take instructions because those are coming after 10 years, 13 years.
If you seek adjournment for seeking instruction, the court will not dismiss the cases on this ground. The court is not in a disposal mode. The court never. If since the matters are old and in the most of the cases, I presume that the order must have been complied with. And therefore, I want that as far as it is possible, these old matters should be disposed of.
Fair enough, your lord.
And whenever there, each of the cases, if the order has, and therefore, in fact, at the request of the members of the bar, the list was notified on Tuesday, I think.
My lord is saying that in fact notified in respect of all cases, but in the new cases, well, in fact, that has not been notified, so that.
New cases, the first case is of 2011, contempt matter.
That is the oldest one.
I assure you that I will not dismiss or dispose of that case even on the ground of like it is old and therefore. So even 2011 matter, if required, I'll decide that on merits.
Okay, my lord.
It is not that these matters have been listed. Well, we are concerned, as a Chief Justice, I am concerned about the fact that there are 10,000, more than 10,000 contempt applications pending.
We're grateful, my lord, because some lordship, we're also very much obliged to lordship because some bigger work you have lordship done. That's why express our gratitude, man. It's
Thank you.
Item 490, there is a personal appearance, my lord. Item 490. 490.
And wherever the officers, government officer.
Yes.
Learned government advocate has asked me to say that after 12.
It has been complied with.
No, not complete. They are personal appearance.
Personal appearance after 12. 2 p.m. जाके जी.
These matters should fall down at 12.
12
o'clock.
12 o'clock.
After 12:30. 12 or 12:30.
At 12, wherever the personal appearance has been directed.
Well, matter item number 2.
May it please your lordship. The order has not yet been complied with. And your lordship, I have given a chronology in the shape of affidavit. No,
Let me see the order.
yes, so again, your lordship may kindly, I have given all the entire orders, my lords.
No, where is the order passed by this court?
I submit one thing. What has happened in this case? There is an order of the Honorable Apex Court. Thereafter, the contempt proceeding was initiated. And the secretary, being called upon by the Honorable Court, secretary filed an affidavit stating inter alia that we have complied in a particular manner. he filed a reply that this is not the proper compliance. So in these type of cases, what I beg to submit your lordship is that if at all he is not satisfied, that may be a different cause of action to file another. But
Let me see, Mr. Let me see the order.
Yes.
And let me see the non-compliance
Yes.
or compliance, and let me see, hear him. Yes. Prove the order.
Yours page 9, Lordship. Page 9 of the content petition. I exterminate chronology in shape of a affidavit. That is also flag M. That is also the order.
Just a minute, let me see the order first.
Yes, Lordship.
Page 9.
Page 9, there are batch of matters, Lords. And this writ petition is 6877. Second row.
Page 9, where is the operative portion?
Lords. It's my lord. Page 15, Lordship. 14 and 15. Yes, Lordship. 14 and
14 is the, yes.
page 14 and 15.
So what happened after Supreme Court's decision?
Lords, challenging this order, state had moved honorable apex court. And that is also, that order is at flag M. I have given that order. Their honorable apex court said, you pay the dues in 2 installments. 50% you pay now after.
You are alleging disobedience of the High Court's order or Supreme Court's order?
Disobedience of High Court's order. This honorable court's order, 30/2010 order.
No, but 34/2010 order merged with the order of Supreme Court.
Supreme Court contempt was pending, Lords, after that.
Contempt may be pending.
Yes.
But now the disobedience of Supreme Court's order, we cannot entertain.
But now, Lord, what has happened is, mill is running me. I am claiming my.
Maybe the question is, whether this court has jurisdiction
Yes.
to entertain this contempt application. Because that order, what you are saying has been violated, has been modified by the Supreme Court. That merged with the Supreme Court's order.
Only,
So now if the violation, if any violation is made out, that is of the Supreme Court's order.
only one
So you can
submission.
approach the Supreme Court.
Probably only one submission before the Lordship. That's what I have understood. The 34/2000 order passed by this honorable court was challenged by the state before the honorable apex court. Honorable apex court also confirmed this order and said you pay in 2 installments.
No, the court has, the Supreme Court has modified.
Your Lordship, kindly see the order is there.
Yes. So the appeal has not been dismissed. The appeal has been disposed of.
Yes.
And there is some modification. Therefore, if you are alleging disobedience, then you will have to go to Supreme Court, not here. The question is of jurisdiction.
As well. As well as.
The petitioners in the present contempt application have alleged disobedience of this court's order dated what is the date?
34 Lords.
34
2010 Lords.
2010, passed in WPC number 3546 of 2000.
6877 Lords.
Huh?
6877. That is in second row.
WPC 3546.
No, that is the leading case. My case is 6877 at second row.
6877
6877 2007.
of 2007, which was disposed of along with other analogous matters.
Yes, sir.
First off, operative portion of the said order reads as under for the reasons. शुरू करोगे? Last paragraph. First off, it appears, it is manifest from the contempt petition itself that the state of Odisha has had put to challenge the above mentioned order of this court by filing SLP giving rise to SL civil leave to SLP bracketed C number 354-355/2009. First off, the said SLP came to be disposed of by the following order of court. First off, next, in my considered view, thus, this court's order dated so and so, violation of which has been alleged in the present contempt application, merged with the order of the Supreme Court dated 21/3/2017. First off, accordingly, if according to the petitioner, the Supreme Court's order has been disobeyed, this court cannot entertain the present contempt application. First off, this contempt application stands disposed of accordingly.
Our submission we have completed order.
Only one submission. In this particular case, state SLP number is 860 of 2011. Let's see, kindly note it.
860 of
2011 in this case.
Thank you. Thank you.
Our case we have completed order.
That in Supreme Court, you will take that.
Grateful. Item number 3.
My lord, on behalf of my senior Bijapan Pereda, I seek for the adjournment.
My lord, the contempt has been initiated against a judicial officer, SDJ. So how can such a contempt SDJ of Balangir, Naya God?
What have you done?
Judicial order against the judicial law.
My lord, file is misplacing, kindly adjournment.
Then tomorrow you can file contempt petition against us also.
Yes.
Very risky.
Next week, file is
No.
The petitioner has, petitioner in the present contempt application has alleged disobedience of this court's order dated 6/12/2011, passed in WPC number 6036 of 2011. Stopped by the said order, this had disposed of the writ petition with the petition was dismissed with a direction to the then SDJM Nayagarh to deal with the complaint lodged by the rural labor inspector inspector Nayagarh under the Payment of Wages Act 1936 and dispose of the same in accordance with law within a period of 3 months. Stop. It is the petitioner's case that the SDJM Nayagarh has committed contempt of court by not disposing of the said case within a period of 3 months as was directed. Stop. Next. After having perused the order whereby the current SDJM was directed to dispose of the case and the averments made in the present contempt application, I am not inclined to proceed in the present contempt matter. This contempt proceeding, contempt application stands disposed of. Yes, item 4.
Yeah, please, Your Lordship. The order dated 12/9/2011, page 7. Kindly have a glance at the order.
Yes,
Disposal of the representation by the OP number 1.
where is that?
Page 7, it has been mentioned
Page 7,
of the content petition.
contempt petition.
Yes.
Contempt petition has only 5 pages. All right, yes.
Considering the nature of the grievance raised by the petition, the rate is disposal. Directing OP number 1, Chairman of Orissa Cooperative Housing Corporation Limited, Bhubaneswar, to consider and dispose of representation and unaccepted within a period of 45 days. Period that has not been complied. The representation with regard to the salary of the petitioner for the period from 17/10/2008 till
So whether the representation has been disposed of?
nothing has been communicated.
Yes.
My lord, in this case, there are 2 contempt notes, so Procedural 1 and 2. By order of this honorable court, 2 was deleted. And so far as 1 is concerned, by order dated 5th September 2013, he was directed to file requisites for issuance of notice. Then the next order reveals that AD not back from OP number 1, and thereafter there is no order. So OP number 1 is the bank, I think, na? Bank. So
Which bank?
Orissa Housing Corporation Limited.
Housing Corporation for
Whether notice was issued to the bank?
AD has not returned. Notice has been
No, in the writ proceeding. In the writ proceeding, whether notice was issued.
in the read for this. No, it was disposed of the same day.
No. Then no contempt.
Same day.
The petitioner has,
And you lost him a disposal with a direction. If the salary has not been paid, let it be paid.
we have the, in contempt jurisdiction, that we have, the court has only 2 options, either to punish or let him off.
And you also for a moment,
It cannot be given.
and then for a moment, kind of glass to.
Give you liberty, not direction. Just a minute. The petitioner has alleged disobedience of this court's order dated 12/9/2011, passed in WPC number 23311 of 2011. First off, by the said order, the writ petition was disposed of with a direction to the opposite party number 1, that is Chairman Odisha Cooperative Housing Corporation Limited, Janpat, Bhubaneswar, to consider the petitioner's representation and dispose of within 45 days from the date of receipt of certified copy of the order. So it is an admitted fact that before passing of the order dated 12/9/2011, the Odisha, the contender was not issued notice the said order was passed in the absence of the corporation. Full stop. Next, in such view of the matter, I am not inclined to proceed in the present contempt case. Full stop. Next, the petitioner shall, however, be at liberty to pursue his remedy before the appropriate authority in relation to payment of salary. In relation to payment of salary, which according to him, he is entitled to.
Annexure 5, page 11 for a moment. You have received the notice and issued a letter to the petitioner to appear before the hearing. Annexure 5, and for a moment, page 11 can overturn. You have received the notice. The president of the
Contempt case.
Bhubaneswar has been pleased and directed to appear before 7/12 in pursuant to the order of this court. In this office, chairman, hearing regarding release of area salary without fail. I was appeared, thereafter nothing.
He may pursue that.
That is contempt matter.
Yes, they after receipt of the order of the honorable court, they have issued the letter.
I understand that. The order, if the order is passed in someone's presence, a different matter. Very difficult if without notice an order is passed.
Item number 5.
Number 5 already complied.
Yes, it is already compliant.
Item number 6.
It has been complied with.
Yes, my.
There is no representation on behalf of the petitioner.
List.
A so-called reply has been filed on behalf of
Supplementary.
the opposite parties, from which it appears that this court order violation of which has been alleged has been complied with. The contempt proceeding stands dropped.
Item number 7.
My lord, item number 7 became
Infructuous.
Item 8. Item 8, my lord, I have to take instruction, my lord. The lordship will take up this matter another after 15 days, my lord. And after 15 days, my lord, the lordship take up to the matter, my lord. After 15 days. Which chapter, my lord?
Let me see whether the order is, what is the order? What is the order?
I have not taken instruction, my lord. What is that?
What is the order? You have to take instruction.
It is regarding payment of my lord pension. Affirmed in recopy. Then Honorable Supreme Court also directed that dismiss the appeal filed by the state. Then my allegation is that in spite of all these orders, my client has not received any payment.
All right, let me see the order.
Here is a problem, your lordship, in the order itself. Instead of filing the certified copy, why I have filed another copy in which similar orders have been passed, I don't remember now, my lord. Your lordship may kindly turn to page 6. That is the order of your lordship and honorable single judge. Name is Prabodh Kumar Patnaik, my lordship. That is not of the petitioner.
Whereas, if your lordship would turn to page 8, paragraph 3, my lord, this point involved in this writ petition is no more res intriga, as this court has already decided a similar question in the case of Ramnarayan Padhi versus State of Orissa and another, reported in 2006, 1 OLR 293, where it was held such and such. So now I cannot say, my lord, why I not that order. And this order, my lord, Ramnarayan, my petitioner's order, that was affirmed in writ appeal filed by the state. That is at page 10, my lord. Your lordship would find at page 16, page 20, in our considered view, the learned single has rightly interpreted the amended regulations referred to such and such and granted the relief where according valid and cause and reason in the impugned order. For the foregoing reasons, we do not find the impugned order either erroneous or error of law. Hence, the appeal must fail and accordingly dismissed. They carried it to my lord in Supreme Court. Honorable Supreme Court decides it page 23. I was made party there. Third paragraph. No. The special leave petition is accordingly dismissed. However, 3 months' time is granted to the petitioner to comply with the direction given by the learned single judge, which was confirmed by the division bench of the High Court. It is needless to say that if the petitioner fails to comply with the order of the learned single judge in next 3 months, then the concerned officer will make himself liable to be proceeded against under the Contempt of Courts Act 1971. The registry is directed to send a copy of this order to the Registrar General Odisha High Court, who shall ensure that the same is brought to the notice of the learned judge who decided the writ petition filed by the respondent number 1.
But how can you maintain if you don't have the order and if you don't know the order?
This honorable court's order.
Yes,
Today only I saw it, your lordship. So my lord may grant it sometime. I will get the certified copy if it is available, or I'll make some.
yes, you please seek instructions.
Yes, my lord. But there is a direction of this Honorable Supreme Court, so it must have been complied, I think.
That you will have to say.
And apart from that, what your lordship has held in item number 2, it is a, so as per his own case, it is a violation of the Honorable Apex Court order.
The Apex Court has not done anything. The Apex Court has affirmed. So the doctrine of merger will not apply in this case.
Specifically directed, rule High Court's order, single judge bench is
2 weeks.
2 weeks.
Little more, your lordship. I may have to get a certified copy of lordship's order.
No, don't worry about that. You apply for certified copy, you will get that. 2 weeks.
Item 9.
From the page 21 of the content application, page 21 of the content application.
What is there?
Considering the page 21, considering the nature of grievance raised by the petitioner, the writ petition is disposed of directing the appeal department 1, that's Commissioner cum Secretary, School and Mass Education Department, Bhubaneswar, to consider and dispose of the representation of the petition from the unexpected within a period of 3 months. Then, my lords, they have not complied with they have not disposed of the representation. Again, I have filed a content application by the annexure 2, my lords. And in that case, my lords, case 29, the Honorable allowed another 4 months time to comply the court's order. But that has also been already complied.
Who have not complied with? Who has not complied with?
One minute.
Opposite party number 1.
Yes, no, only one opposite party, my lords.
Opposite party number 1 is still holding the position.
My lords,
He's changed, I think.
Each time is allowed for the contender, to seek instruction. And instructions and inform this court as to whether this court's order has been complied with or not. In fact, you can warn. Now the time has come when the court will convict one of them. This is 2012 matter. He is alleging disobedience of the court's order, and you don't have any idea whether the order has been complied with or not.
Within 2 weeks, we'll get instructions.
Don't compel me to.
Item number 10.
on behalf of enforcement, no instruction.
No instructions, not disposed of, not trust. Yes.
Item 11.
No instruction. Not present. As
Not
no
present.
instruction is issued, matter is not.
Item 12.
There is no representation on behalf of the petitioner. It appears to the court that with the efflux of time, the petitioner has lost interest in the present matter. The contempt proceeding is dropped accordingly.
Item 13.
Yes.
Please, please start.
Attends.
Here.
Same order.
Item 14.
13 is dismissed.
Same order.
Item number 15.
No instruction.
Item 16.
My lord, already complied on behalf of BK Naik. Complied.
Item number 17.
Item number 17, I am for the opposite party complaint, my lord.
Complied with.
I am for the contempt, my lord.
You are the contender.
And this is the examination matter with regard to 2013 All India Trade Examination. That examination is over.
Become infractions.
Infractions.
Item number 18.
Lost interest.
Item 19.
Same order.
Item number 20.
No instruction. No instruction. No instructions. Not rest.
Item 21.
None appears.
Item 22.
No instructions.
Item 23.
None appears.
Item number 24.
None appears.
Item number 25.
None appears.
Item number 26.
No instruction, my lord.
No instructions.
Item 27.
Item 27 on behalf of Mr. Purushottam Suri, my lord, he has asked me to pass over this matter. Let me see. Yes, do you have any instruction?
No, the so cause has not been filed.
1 week time is allowed for the contender to seek instructions. Was this case 1 week?
28. 2 weeks.
1 week.
None appears.
Item 29. Item number 30.
39 already complied.
Complied with.
31.
No inspection.
No instructions.
Item 32.
None appears.
Item 33.
33, but there was some time will enter because I am not sure. The whole
33.
file is not received. I pay next week.
33.
Yes, 33.
Let me see the order first. Consider the recommendation made by the collector. That is as requested on behalf of the petitioner, this matter on 1 week.
Item 34.
No closure. Complied with. Complied with.
And complaint, I have already complained my regarding the substantial allowance. All this, they said that the party complied, my lord. Only for the substantial allowance they are not received. I pay 1 week time to sort for instruction on whether a substantial allowance has been received by the petitioner or not.
But except substantial allowance, all of the benefits are removed.
Was there any direction specific?
No, only reputation has been disposed of, direction to the reputation to be disposed of. Then,
Complied with.
compact.
Item number 35.
But Mr. Counsel, if that is not that has not been paid, please ensure that.
Yes, I have, sir.
35.
The order has been complied, madam.
Complied.
Item 36.
No instructions.
No instructions.
My lord, we have also matter item number 384, 461, 462, 463, 464.
Please, say that again.
My lord, 384, 461, 462, 463, 464.
Complied.
No instruction, my lord.
No instruction. All right.
Item 37.
Complied.
38.
Please, my lord. And we can have a glance to last order dated 7/5/2024. I am for the petitioner. Therefore, the worship was directed that Eastern Company, otherwise action as per contempt will be initiated.
My lord, I am appealing for the university. University already given a letter to the Secretary of Education to release the money in view of the contempt proceeding. Therefore, sometime maybe he will be paid his money. We have already intimated the view of the court and the orders of the court. The secretary is to release money so that we will be giving it. University doesn't have its own fund. It gets the fund from the government. Therefore, it is left to the government to release money.
The order passed. On 5/2/2015, the honorable civil judge has disposed of matter. Of course, thereafter they went on writ appeal. Writ appeal has also been dismissed. Thereafter, my lord, but prior to that, since they have not complied, and the contempt petition has been filed, which is before my lord.
So you are for the.
I am for the petition.
And you are for?
I am for the university, Sonpur University.
So when did you decide to comply with the order?
Pursuant to your lordship's order, we intimated them that they had partially implemented the order. He is getting his pension, etc. He is getting all money he got. He to get another 71 lakhs. We will be getting it shortly because we are getting.
When was he entitled to get 71 lakh?
With effect from the date of the first order, since the appeal was with the earlier order.
We are initiating contempt proceeding in this matter against the university.
My university, one date may be given.
No. Ask the vice chancellor to be here.
On this 24/6/24 only, we have invited them unless you pay.
Why did you not comply with the order earlier?
I am at the receiving and I am at the receiving and they have to pay the money.
Who has to pay?
Government has to pay the money.
Did you make that request earlier?
Madam,
When?
I have given it earlier also.
When?
That is how he has got the money, my lord. That is how he has got the 31 lakhs he has got.
But that is now, my lord, with regard
Pursuant to the order. Pursuant to the order.
Yeah, I am not satisfied.
My lord is filing this affidavit.
Right.
So within.
Suppose reply be filed on behalf of the contemners by 2 weeks. So stop. It will be obligatory for the contemners to furnish the names of the vice chancellors of the university, names of the persons who functioned as vice chancellor of the university from the date when the order was passed till date for this court to consider initiation of contempt proceeding against all of them if a case is deliberate disobedience of this court's order is made out. So stop. It is further observed that if by the next date the order is not fully complied with, the contemner, the vice chancellor, and who is the secretary?
State is not a party in the.
State is not a party.
The vice chancellor vice chancellor of university shall be required to be present in court.
Yes. I will be filing the affidavit and
Do whatever you want to do. You can beg, you can borrow, you can steal, but you will have to pay. And you may go to there also. That's a safe place. But this is too much. This is 2015 order. And he has not been paid.
After the dismissal of the writ petition, we have already paid him the current amount we have paid. It is only in respect of the past due.
You are required to fully comply with the court order. Since you have not complied, it appears to be deliberate. Either you don't have any respect for the court order.
It is not my case now.
You can go, you can beg before the secretary of the department for the money. Otherwise, I assure you that the person will be taken to task.
Item 39.
Yes. Non appears.
Item 40.
Partly complied with.
Complied with.
No, partly complied.
What has not been complied with? What is the order?
Was
We understand the meaning of partly complied with.
release the pensioner benefit matter. Release the pensioner.
What was the direction?
Direction was to release the pension, but provisional pension has been released, final pension has not been
Let me
released.
see the order. Where is that?
Page 11. Petitioner is entitled to all his emoluments till he was superannuated. His pension also be calculated properly and the period salary
as well as pension be released within a period of 1 month from date of communication of order.
Yes, so what has not been paid? Pension you have not.
Pension not been released. And
Yes. Whether any so-called has been filed.
so-called has been filed, in the so-called they have, I think a writ appeal was pending, but writ appeal dismissed.
Writ appeal is still pending.
No, dismissed.
Dismissed.
When was that dismissed?
12/9/2017. Writ appeal number 600 of 15.
Thereafter, the so-cause is filed.
What is this?
My lord, everywhere it is writ appeal is disposed of.
Huh.
He is saying that.
Writ appeal was disposed of in 2017.
And he has been taking the provisional pension
So
only.
the direction of the fine pension, who is the authority to sanction?
The
For DO.
DO,
DO, which district?
Puri.
Huh?
Puri, DO,
DO Puri.
DO Puri.
Ma'am.
After having perused the order passed by this court, violation of which has been alleged in the present contempt application, and the so-called affidavits which have been filed on behalf of the opposite parties, I am of the considered view that the contemners have disobeyed this court's order, order dated so and so Ligdana, past tense so and so. To stop. In the court's opinion, a case of gross contempt of this court is made out.
one chance may be given.
No. This is the case in which I am punished, the officer.
Only 1 week.
No, not at all. Don't do it. Never do it. Let the it has been let the district education officer. Which district?
District Education Officer, Puri.
Education officer
Puri be personally present in court on next Friday with a so cause as to why a contempt proceeding be not initiated against him and he be not punished for deliberate disobedience of this court's order. Stop. Next. The secretary, which department?
School and Mass.
School and Mass Education Department is directed to ensure that all the officers who were holding the post of district education officer from the date of dismissal of the writ appeal on
17/12/2017
are present in court on that day. Please ask her. Please ask the secretary.
All the DOs.
All the DOs. Yes.
My lord, if in the meantime we will comply.
You know, in this case, even if they comply, I will punish them. You just think of this poor fellow. He is fighting for what he is entitled to.
That to pension.
And see the observations which were made by the learned single judge. It's a proper adjudication of a case. And despite that, you are not, how dare you can? So the actions shall start from here.
At a law 41 of life.
The order dated 16/12/2011, order passed on 16/12/2011. And in this contempt petition, last date on 21/8/2017, the order passed to comply the order.
So whether the order has been complied with or not?
That is till,
My lord, just now I have received the instruction in that case. I am asking him to come and again just now that they have been paid with certain amount. That instruction.
No certain amount, let them come.
My lord, I have just now received. After one passover, you will
All right, see what has been done.
see the customer. Huh? Yes. After one passover. Yes.
41.
41, sir.
41 by the order dated 21/8/2017 in this contempt petition, the order passed and direction to comply the order. Thereafter, they have not complied. The order passed in the writ application, page 2, para 2 of my contempt petition, your lordship may kindly see. I have stated WPC number 32132 of 2011. Order passed on 16/12/2011.
No, where is the order?
Page 2, para 2 of my order, I had stated that order and also enacted.
Page 2.
Page 2, para 2 of the contempt petition. That this honorable court, while disposing the writ application on 16/12/2011, directing the opposite party to pay the time bound advance on scale of pay within the stipulated period. The order is there. The petitioner in the writ application has filed paying for a direction to the opposite party to release differential area due for the petitioner for a period from 31/12/2001 to 31/12/2005. That is from the date of
So
positive.
whether representation has been disposed of.
Till today, they have not complied that order, though the order passed on 21/8/2017 in this contempt. The order direction.
Mr. Whether your representation has been disposed of or not?
Representation has been disposed of.
Disposal. No, my lord, that complied, they have not complied.
Whether the order representation has been disposed of,
No, my lord,
not disposed of.
that is not disposed of, not complied.
Not complied, that was the compliance disposal of
That
representation.
representation till today, my not disposed of.
It has not been disposed of. So if it is found later that it was in fact disposed of and you misled the court by telling that it has not been disposed of, then the court may initiate contempt proceeding against your client.
Then I had to take instruction from my
You have
client.
to take instruction
But
that
I had not, they have not complied, they have not served the copy of the compliance order.
all right, let him take next week for the parties to seek instructions as regards compliance of this court's order.
Item 42.
Violation of the schedule.
42. May I please, your lordship?
Item,
42.
yes,
14. The non-compliance of order dated 14/5/2015, my lord. But this has been already upheld in the division bench. My lord, they have partly complied the order. They have regularized my service. But when preparing a reduction list, my lord, they have
what is the order? What was the order? Let me see the order.
order dated 14/5/2015, my lord.
Where is that? Annexure 1.
Yes, my lord.
So what is this order? Where is this WPC 19921 of 2010?
My lord, I have a copy, my lord.
Wow. We have copy.
If your lordship permits, my lord, I will file that copy.
All right, what was the order?
My order, my lord, the Annex 10, my disengagement order was cancelled. My disengagement order was cancelled. And my lord, the court, honorable court directed to grant me all consequential benefit. my lord. Here, my lord, basing upon that order, my lord, this writ petition was disposed of. Suryakanti Das, my lord. Here they have regularized my service. But, my lord, while preparing the gradation list, they are taken.
Was there any direction for preparation of gradation list?
No, my lord, direction was to grant me all consequential benefit.
Okay, consequential benefits, that's quite vague.
No, they have regularized my service, my lord.
Yes, yes.
But they have to regularize my service from 2009 instead of 2010. My lord, the dispute was whether the appointment should,
What is the direction in that case? WPC, that it should have been regularized since 2009.
yes, my lord.
Read the operative part of the order.
But in Suryakanti Das, considering the
WPC 1991, 19921.
in that view of the matter, the office order under Annex 10 is quite and the opposite parties are directed to the all consequential benefit to the petitioner.
Yes.
My lord, consequential benefit, my lord,
Consequential benefit, there is no end to that. Consequential benefit.
my lord, I was appointed in 2003, my lord.
That is a separate cause of action altogether. Mr. Counsel, we are sitting in contempt jurisdiction. So we have our own limitations. We cannot go beyond what has been directed to us before. So if you are entitled to some consequence,
Other part I will challenge, my lordship may have granted me liberty.
the from the submissions advanced at the bar, it appears that this court's order dated 14/5/2015 has been complied with in as much as the services of the petitioners have been regularized. Full stop. Learned counsel for the petitioner has submitted that the court had directed a regularization of the services with all consequences, benefits, but they have not been granted consequential benefits in accordance with law, in as much as the gradation list has not been properly prepared. Stop. That aspect does not lie within the contempt jurisdiction, within the scope of the present contempt proceeding. Stop. The contempt proceeding stands stop with a liberty to the petitioner to raise his grievance as regards, raise his grievance before appropriate authority in accordance with law.
In item 30, this is the instruction I have received that he has been paid with the area pension of 10,79,000.
It's not only area, but from 2005 to 2010, only
That
area
amount is to be regularized.
I have received, but the pension from 2009 only dead.
And the area he has received 10,79,000.
So
All
pension is not getting.
I'm not
Pension-
getting,
He is getting,
I'm not claiming area. I'm not claiming area. I have already got area from 2005 to 2009.
Whether he is getting his pension or not.
that the letter shows that they have given the TDO to regularize it and release the pension.
All right, let them come.
Lord may give me one chance, I will file the affidavit, otherwise.
Let them.
Item 43.
Yes, sir. Something is there.
43. 43.
No is actually. No is
No, no, please. No, not this. Whether order has been complied with or not. Yes, sir. Mr. Mohanty, we are struggling with this situation. Here, the circumstance is that an order was passed in 2015. Lawyers do not know what happened. You have not cared to file any affidavit regarding compliance or non-compliance.
In this case, let me see.
In no case,
Yes.
these cases filed in 2015 or 13 or 14, so your department is not filing affidavits, compliance affidavits or whatever. Everything cannot be left to the mercy of the Lord. Cannot be. As requested on behalf of the petitioner, list this matter on 1 week.
Item 44. May I appeal? The order dated 29/10/2015 has not been complied with, madam.
Has not been complied with.
No, madam.
Very good. What is the order?
Order was direction was given to the sole opposite party to furnish the certificate copy of mutation case number so and so within a period of 15 days from the date of production of certificate copy. In this case,
Mr. I'm making it clear. I'll direct the presence of the chief secretary. Because it is not case of like one non-compliance or two non-compliances. In each and every case, you don't have any instruction. You will have to have some policy or face consequences. I'll direct the presence of chief secretary in the next date in one of the cases. Yes, order. Where is the order?
order as
What is the order?
at page 7, my lord. Considering the innocuous fear, the petition disposed of.
So you have not been furnished certified copy.
No, not at madam. State has also took time on 16/4/2019 to obtain instruction, madam.
It's a mockery.
The direction to hand over the certified copy of the.
So he applies for certified copy, you don't give certified copy, and he comes to the High Court. High Court issues a direction to you to please give him the certified copy, and you don't have any idea whether the certified copy has been given or not. And are you sure that certified copy has not been made available?
Yes, sir, they have not at all.
Let me take instruction next week. Next Friday, Lordship.
There is. The petitioner has alleged disobedience of this court's order dated 29/10/2015, whereby the who was directed? Bhubaneswar was directed to furnish certified copy of mutation case number 1203 of 1993. First off, learned counsel for the learned AGA does not have any instruction as to whether the order has been complied with or not. Learned counsel for the petitioner states that the said order has not been complied with. First off, let the Tahsildar Bhubaneswar be personally present in court on 2 weeks. जो भी पर्सनल अफेयर्स का केस होगा डॉक्यूमेंट
Item 45.
no representation.
Item 46.
May I please, your lordship? When non-compliance of order dated 31/10/2014, my lord, or the order was
For consideration of my representation, my lord, I have no instruction whether the representation has been considered.
No instruction, you don't have any instruction because he does not have.
I don't have any instruction, my lord. 47.
Disposed. Disposal.
No representation.
48.
No representation.
Item 49.
No representation.
Item number 50.
No representation.
Item 51.
The petitioner approached the honorable court mirror for rehabilitation appointment mirror. For rehabilitation appointment. The already 15/12/2014 mirror. The court directed to DEO to consider a representation and dispose of this same. Therefore, did not dispose in time. Second time I approached in first contact. In that case, the court directed to comply the same within 2 months. Therefore, they have, in spite of that, they did not comply. Then I filed this application. They have filed a so-called annexing that the represent the disposal of the DO, saying that he has sent the documents to the higher authorities, and accordingly, my representation has been disposed of. They also kindly page 8 of their so-cause.
So-called is not there on record.
My lord,
So-called, hai? No.
so-cause of the.
What is there in the so-called?
My lord.
Give him a copy.
In the 23/11/2016. So-cause the SME, my lord.
51 item. 51. Okay, 474/2016.
हाँ कौन था हाँ
474. କହୁଛନ୍ତି କିନ୍ତୁ ଏତେ ନାହିଁ ଦେଖା ଟିକେ ସୋକସଟା representation has been disposed of. He is saying that it is in a erroneous manner.
What is the representation?
representation for consider application for rehabilitation.
What is the disposal?
The DO said that I have sent all the documents of the petitioner to the director and the commissioner, but they have not acted upon the same. Accordingly, my representation is dismissed and disposed of.
Dismissed, disposed.
Dismissed.
What was your prayer?
My prayer to give me appointment rehabilitation scheme of my deceased father-in-law. My Mr. Value service was, he has died. Rejected.
So who was required to dispose of your representation?
My lord,
Who was required to dispose of?
we leave you, my lord. District education officer, my lord.
So DO has done whatever he could do.
He has disposed to saying that I have sent the necessary documents to the director and asked for necessary instruction, but they have not supplied necessary instruction till date. Accordingly, my representation rejected and disposed of. That is their his stand, my lord.
What is
The DO is supposed to only place the before the higher authority for necessary consideration. And he direction was to the DO. So he has done at his level whatever he best he can do. That is what this offers.
file your so-called, we will see.
Pardon, Director.
File your reply, file your so-called.
That is
That is not a disposal of representation.
The director as well as the particular contempt.
Let's see.
file the reply.
The consequence of that order would be that the director would be held liable for contempt of court.
I will take instruction from the director.
Seek instructions.
My lord, 2 weeks time.
2 weeks' time is allowed for the state to seek instructions in the light of the nature of proposed reply which has been filed on behalf of the concerned district education officer. Item EFC2.
May I appeal, your lord? When the order of this honorable court has not been carried out to give the RO in favor of the petitioner's manner.
What is the direction?
That is my lord, that is my lord. Annex 1, my lord.
Yes.
But to them, regional manner, they have the counter manner, regional manner.
File it in the registry. Yes, what is your stand?
My lord, I have filed the show cause. Your lordship, valid points have been raised in the show cause. Lordship may see para 3 of the show cause. Filed by the opposite party number 2. That is the Tahsildar Lepripada. There is a development in the matter. The Additional Commissioner of Settlement and Conciliation Sambalpur has passed order on 8/5/2013 application number so and so with a direction to verify the lease cases to ascertain the genuineness of the claim from the lease quota proceeding. Further, it has also been directed to the Tahsildar to dispose of the cases after verifying all required papers, keeping in view the provisions contained in Rule 34 of the OSS rules, along with Forest Conservation Act 1980. In this connection, the Tahsildar.
So this order was passed without filing any counter affidavit.
Yes,
My lord.
Then it's very difficult.
on the first day.
The petitioner has alleged disobedience of an order dated 13/10/2015, passed in WPC number 17808 of 2015. Operative portion of which reads as under. Stop. Next. It is evident from the records that the aforesaid order was passed by the learned single judge on the very first day when the writ petition was taken up for hearing without filing of the counter affidavit. Stop. Next, a so-called affidavit has been filed on behalf of the opposite party number 2, explaining the steps which have been taken pursuant to the aforesaid order of this court. Stop. This said affidavit is dated, was filed on 31/8/2016. Stop. Taking into account all the facts and circumstances in totality, I am not inclined to proceed in the present contempt matter, as no case of deliberate disobedience of this court's order is made out. Stop. It is, however, observed that the petitioner shall be at liberty to pursue his matter claim before the appropriate authority in the light of the steps which are said to have been taken by the opposite parties as disclosed in the so-called affidavit filed on behalf of opposite party number 2. Contempt and disposed of accordingly.
No, it doesn't really. Please assume. Hey.
Item number 53. Well, non-compliance of order dated 5/1/2016. You lords may kindly come to running page 7, the operative part of the order. The order was passed in presence of all the parties appearing for respective parties. And a direction was given for regularization for taking a position with regard to regularization of service of the petitioner on the basis of the resolution already passed by OP number 2 and 3. The time stipulated was 3 months.
Yes. So the opposite party number 1 was required to take a decision.
Yes.
Whether the decision has been taken or not.
Nothing has been, no decision has been taken, nor they have filed any show cause.
Sir, 1 minute.
And marketing board.
Yes, madam. I think in this case, state respondents may not be appearing because the Osama board here
So marketing board is this.
is represented through different councils appearing.
Whether the board was represented by someone.
Yes, before the court, when the order was passed,
Ah.
the board was represented by, you Lakshmi, kindly see running page 7, paragraph 3. OP number one was represented through one SB General and counsel for OP number 1. At that particular point of time, he was the counsel, so he appeared and he, in his presence, the order was passed. But now he is not there in the panel.
All right, issue notice.
Item lot 54. Oh, right.
8 weeks.
54. 54.
50?
54.
Yes.
54.
No one appeared. Item 44.
55.
Compliant.
Sam for the university ones. Item 56. 56 minor not complied in spite of minor variation, specific variation for last 8 years they are not complied minor.
What is the order?
Otherwise minor is at page 3 and renewed the ordering portion minor. Which is at page 5 minor. Towards the last paragraph, this court has already considered the similar nature of grievance in the case of Pramlota Pandya versus State of Orissa and others reported in 2015 or 2014. 2014. Let the authority consider the case of the petitioner in the light of the ratio decided by the Pramlota Pandya case in accordance to Supreme Court decisions minor. And they have not complied minor.
So who was complied?
My lord, technical compliance affidavits have been filed.
Only one issue comply minor, but no two to comply.
One is to comply. Yes, government has.
Government has
Then my senior inspection. And for the one me.
two, yes.
How much time? But this is of
Today, my name may be recorded. Dhanand Mahapatra and Buketa may be recorded. For one me, I will appear and I will be bringing all these factors.
trying to accept notice on behalf of which opposite party?
So,
Copy number 2. Copy number 2. Does this says 2 weeks
And
for him to file so called affidavit?
Item number 57.
my lord, on the submission of my learned friend, the OP number one has complied his part.
No. That they will say what they have complied or not, they will say, my lord. If it means to say,
Okay.
57.
No one appears, just for the fault.
Item 58.
Come on.
59.
Still not.
Item number 60.
Already complied with money. Complied with.
Item 61.
No one appears.
Item 62.
Come on.
Item number 63. May I please, your lords? My lord, ordered family pension matter. Ordered 8/7/2015. 8/7/2015 not complied with.
Not complied.
Just now I received a letter that the order has been complied. There is an office, you can verify. Lordship, I am giving a copy to you, Lordship may fix it.
Another day. Now just I received a copy of the,
What was the order?
I have not seen it.
What was the order?
After the order in the meet.
So, my lord, this ordered 8/7/2015. Ordered 8/7/2015 has not been complied with. 8/7.
What was the order?
Order was not directed to to grant family pension. You will also guys the paragraph 13 and 14 in the operative part of order. Documents. 13 and 14 last operative the two parts. On taking
There is no such direction.
directed to grant you will also
If there was dispute, it is apparent from the operative portion of the order. The court records that as to who are the sons and daughters of the deceased through first wife and second wife. So that was that
not complied, but till that not complied.
no question of. Following is the operative part of the order, disobedience of which has been released in the present contempt application. Stop. What order has been passed?
Well, this is order 25th. Now they have copy, one copy has been served 24/3/2012 prior to the order.
Huh?
Prior, now a copy of the order has been given 24/3/2012.
What was the order of the read?
Order of the date you will also can 8/7/2015 also can see. 3/5 read to the 3/5/53/2013.
Considering the nature of the dispute,
This number 3/5
which was apparently involved in the writ proceeding, comma, in my considered opinion, no deliberate disobedience of this court's order is made out. So, it is however observed that the petitioner shall be at liberty to pursue his remedy, pursue his claim of entitlement to family pension. Family pension,
Yes, sir.
in accordance with law. And even before appropriate start.
Matter listed for chair submission essay for personal appearance matters. Item number 480.
Lordship may pass over asking.
Where has he gone?
I am asking the government advocate, he will come. Just 15 minutes.
15 minutes.
GM could actually.
He was directed to be personally present.
Yes, he will come, but hey, Lola, GM could actually.
Is he waiting for me?
No. Our advocate general in charge, he will come and he will address in this case.
Where is the person? Where is the officer who was directed to be here?
Here, item number
480.
480. Yes. Here. 480. Dayanand. Oh, that is Utkal University, Mr. Dayanand Mahapat.
Register. No, Nayak.
Dayanand Nayak.
Register.
This is not state official. The register of Utkal University. 63 টা কোন সোজা ওটা কোড আপনার you are not there. Yeah, advocate for the clear. We'll inform the lawyer.
Personally, the order of personal appearance.
Anything I could inform for that.
Order has personal appearance.
Order number 6.
Order number 6.
17-5 for the protocol.
Number 6 is not there. Make order. Or 80. 168 of 2020.
Yes, sir. Sorry, 8 crores. Sorry, 484, 85, 86. So, I found that.
नहीं पर्सनल अपीयरेंस नहीं होता है
Will be to the question.
पर्सनल अपीयरेंस
Office notice.
नहीं all right next forget office nothing will reply next
Item 481.
481.
481. 481. It's open. Because there was a conditional appointments order that we unless and until we comply the order, then there will be personal appearance. And we complied that order. How is that compliance?
all right and counsel for the you represent whom
And for the investments, the register.
for
Register
the
will be very sensible.
opposite party number
There is opposite party number. There is opposite party number 1 and 2. One has already transferred and the new incumbent, one and opposite party 2 vice chancellor.
where is the direction for personal appearance
That, only which there is a direction for personal appearance.
Order number?
Order number 10, my lord.
That is order dated, was 20th February 2024, serial number 4. In content number 3560 of 2023. Paragraph 5 minutes.
The registrar and controller of finance of which university? Which university?
That's Utkal University.
Procedural University were directed to be personally present in court in case the amount as undertaken to be paid was not paid by 25/2024. First off, and counsel appearing on behalf of the contemners has submitted that the amount has been paid. And this court's order, violation of which has been alleged in the present contempt application, has been fully complied with.
If the petition counsel is not there, there may be a problem.
No, what is your stand?
My stand is that means whatever amount due, as per the order minutes we have given you, and that we have filed an affidavit on March 18/5/2024.
In any case, these matters shall be taken up.
Filed on 20th May 24 minutes. That we have complied with minutes.
With this matter on next Friday, within first 5 cases. Yes. There is no representation on behalf of.
482.
Yes, legal.
No, in this case,
9524 order.
in this case, now we have already requested the finance department to create a post mailer, and within 2 weeks mailer will be complied with order.
484.
482.
482.
For a post mailer.
Who is the officer?
Personal appearance, sir. Additional Chief Secretary, Principal Secretary, Water Resources Department, Srimati Anu Gaur.
Which order?
Order my lord, 9/5/24, order of this on the board. So they earlier filed one compliance affidavit, that was they withdrew it. And requested on the board prayed for compliance, but till that they have not complied. And the operative portion of the order, annexus is page 47. The content of para 11, in view of the aforesaid analysis and further taking into consideration the peculiar fact and circumstances of the case, this court grants a last opportunity by directing the contender to comply with the direction of the tribunal as confirmed by this court as well as Honorable Supreme Court within a period of 3 months, hence keeping in view the order passed in case of similarly placed person.
Where is the personal appearance?
Personal appearance, order 9/5/24 order, my lord.
Yes, have you filed your affidavit?
My lord, we have already taken a decision to comply with worship's order, my lord, and we have already requested the finance department to create a post so that they will be observed and regularized.
You have taken a decision to comply with the order. Great. You have taken a decision, then sir, something. You have done honor to the court by accepting that you will comply with the order. And do you have any other option?
No, ma'am.
Why the court should chase you like this? How many orders have been passed? 7 orders.
That is the third contempt. The first contempt, second contempt direction was made and giving them last chance. And this was the third, this is the third contempt.
What is happening?
Suppose was filed, my lord, that was rejected, then we would comply, my lord.
Is this matter on? Only when?
The person is
Who is the
84 years old.
contempt? Who has to comply with the order?
And the principal secretary, my lord.
When the
Water
principal
Resource
secretary, Water Resource Department and Finance Secretary
My lord, both, my
Okay,
lord,
fine.
financial.
shall be required to join the proceedings online. As the court is of the view that the contenders have flagrantly violated this court's order.
So 483.
Yes.
Obliged. 483.
Yes, my lord, regarding the question of the provisional family pension, my lord. Earlier, I am filing one affidavit with your lordships. That
Where is the order?
I'm filing one affidavit, my lord.
Mr. Counsel, you are alleging violation of this court's order.
Yes, my lord.
Where is that order?
The order is, my lord.
Page 8.
Order, page 8 of my contemplation. Page 8 of my contemplation. Therefore, para 4, my lord. In view of the details region stated in the order dated 6/9/2022 part in WPC number 2181/3 of 2022, we stand disposed of in terms of the said order. According to that, my lord, they have not complied. So I filed one contempt. Page 9, your lordship may kindly see.
That we have seen. So the order is complied with or not?
Here also the same secretary, they have requested the EIC to comply the order, give the instruction next Friday or
So what is happening? These orders were passed in 2023.
Yes, sir. Same order, next Friday it shall be complied with yours.
May I submit one thing, my lord? May I submit, my lord? In the meanwhile, my lord, they release the provisional pension from this month, not from the from 2000 the order passed. So I filed an affidavit along this, my lord.
Don't file. Don't file now.
So they have not complied that.
Friday. When who are the persons? Who are the persons to join the court?
Say, what principal secretary, what was the obligation?
No. In this case, that is, in this case, the superintending engineer Angul. Secretary, yes. Secretary and superintendent engineer Angul, both.
Item 484.
My lord, 485, 86, one order. My lord, may kindly see the order.
कोई विड्रॉ किया था नहीं एक साथ बहुत सारे केसेस विड्रॉ किया 481
Is 19,
और 61 64 62 yes
is 19, my lord, may kindly. My lord, have page 19.
yes
So this is examining the case of the prisoner and consider formulating a policy framework to absorb the prisoner considering the service rendered by him at the hospitals. My lord, this direction was given to opposite part number 2 by this honorable court. Now, opposite part number 2 is not the competent authority, my lord. Government is the competent authority. I am filing my so-called, my lord, saying that I have already moved 4 times to the government, and government is actively considering this aspect of formulating a policy of the superintendent has done her partners. My lord, may kindly peruse my.
My lord, let them file a show.
no where is the question of he is saying that opposite party number 2 did not have the capacity to formulate policy. And the direction is to opposite party number two.
Yes.
No person other than opposite party number two can be taken to task.
Malad, when the matter was heard, it relied upon the previous judgments of this honorable court.
We will not go into that. In this case, we are required to see the order which has been passed.
Absolutely.
So nothing beyond that.
Malad, let them give me the show cause
No, whether you can say that opposite party number two was competent to formulate a policy.
Malad, I have not seen the show cause yet. Let them file a show cause. Your lordship may call it next week.
Okay.
I'll answer your lordship.
Is this case on 1 week? So as to enable and then AGA appearing on behalf of the contender has submitted that by the order dated 11/7/2022 passed by the learned single judge. The opposite party number two was directed to formulate a policy for absorbing the petitioner, considering the service rendered by him at the hospitals. Stop. He contends that the opposite party number two did not have the jurisdiction to formulate such policy, and therefore the no contempt proceeding against the said opposite party number two of the writ petition can be maintained. So stop. There is no allegation of disobedience there cannot be any allegation of disobedience against other contemners against whom there was no direction, to whom there was no direction in the said order. Next, then counsel appearing on behalf of the petitioner, however, insists that the state should be directed to file a so-called affidavit stating these facts. So, list this matter on 1 week. But if we are satisfied, we will impose cost on them.
Malad, this was done pursuant to the previous judgment of this honorable court, which they have not challenged before this.
That is not the question. Then the question be in contempt proceeding, I am required to see paragraph 20.
Absolutely.
You are according to them, he does not have the jurisdiction to formulate policy. He will be filing evidence. If I am satisfied with that explanation, I'll make certain observations against your client also.
Malad,
Nothing, no more submission.
Malad, let them cite my copy.
They'll do that. But
Malad, I have a prayer, Malad, can you dispense with the personal appearance?
personal appearance of the, but he is not present.
Malad, he is present in the VC mail.
Where is he?
The superintendent is present in VC mail.
No, I did not see.
Malad, I'm sorry.
She's there, but new face.
All right.
Professor Suchitra Das, Superintendent.
If he was us,
Superintendent MKC.
Suchitra, Professor Suchitra Das,
Superintendent of MKCG Medical.
Superintendent MKGMCH Barampur has joined the proceedings online. Stop. Considering the stand which has been taken on behalf of the contemner on her behalf, comma, personal attendance stands dispensed with for the present.
485 and 486.
Same mail. 485, 486, same.
Same,
Up to 86 is same.
yes.
Item 487.
487, we are complied with, my lord.
No, Malad.
I have objection because the order of this honorable court has not been complied because the lordship kindly see the compliance report.
No, first show me the order.
Yes, sir. Page 9. Page 9 of the content itself. May I read me?
So what was the order of the tribunal?
Right. It is quoted, if page 9, what we can see, the order of the Lana tribunal has been quoted by this, in the order of this honorable court, page 9. In paragraph 4, hence in the result, the way is disposed of directing the respondents to regularize the service of the applicant as a peon in Raghunath Academy, Saraswati Court, Balasore with service and financial benefits from the date of filing of the OA. This exercise shall be completed within 3 months from the date of receipt of the copy of this order. So now the petitioner filed the case before the Lana tribunal in the year 2015.
Regularized or not?
But regularized prospectively, from this month only, they have extended the benefits. But the Lana tribunal, so also this honorable court, while confirming the order of the Lana tribunal, she has already joined my lord and we have regularized from this month.
No, but the direction is, was that with service with and financial benefits from the date of filing of OA. That is the order.
No. Then I'll take further instruction by in this regard.
Further instruction, plus contempt. This court's order has dated 17/5/2023 has not been complied with despite opportunity is granted. In the court's opinion, case of deliberate disobedience of this court's order is let out. So is this matter on next Friday? On which date? Who is
DO Baleswar,
DO Baleswar
education officer Baleswar.
shall be required to join the proceedings online for this court to frame charge of contempt of court against him.
488. For we have already complied with and payment has been released.
You are representing whom?
Well, I am representing the secretary, RMC Mela,
Secretary?
secretary RMC and sub collector. Order has been complied with and the 27 to 80 27 lakhs 81,118 have already been paid by.
He is stated by and counsel representing so and so that this court's order has been fully complied with. Stop. In such court's order violation of which has been alleged in the present contempt application has been fully complied with, though belatedly. Stop. In such view of the matter, the contempt proceeding is dropped. Stop. It is made clear that if it is, there is no representation on behalf of the petitioner. So it is made clear that if later it is brought to the notice of the court that any part of the order violation of which has been released has not been complied with, the court will take a serious note of the matter. So there should not be any complaint.
No.
That any part of the order is yet to be complied with.
489. Order dated 27 page 10 of the content petition. Order dated 27 February 2023 has not been complied with. Order dated 27 February 2023. Page 10 of the.
Yes.
This honorable court has made a directive to give permission as the juniors of the petitioner has been promoted, subject to outcome of the criminal proceeding. And in spite of that direction, Lord, she has not been given permission on the last two occasions, Lord. They have taken time, Lord.
Yes, I filed a so-called affidavit, and on 26/6/2024, watching looked at the 3 criminal cases pending against him.
One case.
Against that was no preferred and recopy, and a lawsuit by order dated, that is 13/11/2023 were pleased to issue notice on the question of limitation. They appeared without, and it was posted to 14/5/2024, appeared and they took time.
All right. It is an admitted position that the order of this court dated 27/2/2023 passed in WPC number 5920 of 2023, violation of which has been erased in the present contempt application, is subject matter of challenge in WA number
1872 of 2023.
1872 of 2023. In such view of the matter, no case of deliberate disobedience of this court's order is made out. Stop the contempt proceeding stands stopped. Yes.
Now, it has been passed in that read of.
Right.
Lost my record personal appearance of being him presently.
Personal appearance of so and so stands dispensed with. Yes.
Item 490.
Yes.
Order that order page 10. I'm sorry, page 12, my lord, updating by page 13.
I don't.
Order dated
490.
24/7/22 regarding release of my pension benefit are not been complied. The order page 20, my lord. Order dated 27/4/23 and operating page 6, my lord, paragraph 6, page 13. To release my pension benefit after their own order. That has been not complied till date. Page 13 kindly see.
Yes.
There was a positive direction, he has not complied, lost my calling.
And the DO Jagatsinghpur is to comply.
Friday, the DO of Jagatsinghpur, I will he should be present also, because in spite of our letter, he has not complied.
Not complied, not appeared also. Not appeared.
The petitioner has erased deliberate disobedience of this court's order dated 27/4/2023, passed in WPC number 580 of 2020 by the Deputy Education Officer. Which place?
Jagatsinghpur.
Jagatsinghpur. Bracketed. Party number. The Mr. What is his name?
Niranjana Bhair.
Naranjana Beda.
Niranjana Bhair.
Procurement AGA has informed this court that despite communications made to him to him seeking instructions, he has not responded. First off, let the contemner be personally present in court on join the court proceedings online for this court to consider initiation of contempt proceeding against him. All right,
491.
2 weeks.
In this case, my lord, I have already complied and sanctioned and pension paper sent to the account general.
But that is not the compliance. Let me see. Where is the order?
My lord, order. At page number 7, my lord.
internal page 3, my lord. Considering submission made by law council applicant parties on careful consideration background, as the present this court deems it proper to dispose of the person to direction director health family welfare department to sanction and dispose the financial benefit is due.
How much time will it take?
Now, we have already sanctioned and sanctioned on 26, 2024 and already sent for the accountant. Department.
When did you sanction?
26 of 2024.
Very recently.
No.
So it will take time. Who is for the petitioner? No one appears on behalf of the petitioner. This matter on Friday. In all cases where the petitioners seek pensionary benefits, they are required to plead controller general or whatever accountant general as party. They are not pleading.
492.
For 92 there was direction. Well,
in this case, my lord, we have filed an interim application, my lord, that the order is challenged in writ appeal number 127 2022. And in that writ appeal, my lord, the this honorable court was pleased to grant the interim order, my lord. Page 7 of the interim application.
the petitioner has raised. This was not brought to the notice of the learned single judge when the matter was taken up. Where is the order for?
My lord, page internal page 7, my lord. 16 to 2020. This was not brought to the notice. No.
It is a supposed affidavit has been filed on behalf of the contender, stating therein that the operative portion of the judgment dated 23/11/2011.
7, my lord.
Huh? Oh, that is wrong. 2021, what is the order?
My lord. So, the interim order granted on 16 to 2022, my lord. In the internal page 7, my lord.
No. Judgment dated 23/11/2021. It should have been.
My lord, this is wrong.
Tell me. That stating therein that the order of this court, violation of which has been erased in the present contempt application, has been stayed by an order dated 16 to 2022, passed in WA number 127 of 2022. So stop. In surgery of the matter, no case of deliberate disobedience of this court's order is made out. The contempt proceeding stands stopped.
493.
In this case, my lord, state has filed a SLP, my lord, and there is an interim order, my lord. Let's see.
Where is that?
My-
What is IA? (15/11/2023).
My lord.
What is 15/11/2020? Where is that order?
Page 19.
Yes. Page 19.
No, 19.
Yes, he's right.
Right.
Learned counsel appearing on behalf of the contenders has brought to my notice various orders passed by the Supreme Court, including an order dated 2/2/2024 passed in SLPC number 2426 of 2024, from which it transpires that the operation of the order, violation of which has been alleged in the present contempt application, has been stayed. First off, no case of deliberate disobedience of this court's order is made out. This contempt proceeding stands stopped accordingly.
With the liberty after disposal of. With the liberty after disposal of.
We don't know that liberty I can't grant because I don't know what will happen. So it will depend on
Allow me to dismiss.
that is always there with you. That liberty we are not taking away. Yes,
494.
same.
495.
495 will also currently pass over after the
Yes, the order has been complied with.
In fact, in 495, even though they have not complied with order parcel, but I find that it's not full compliance of law to law. The EIC is present in court, I have talked to him. So, which kind of lawsuit grant, because it's not in concern with the lawsuit direction law. There was a direction to consider his case, take a decision with regard to the eligibility of payment of those bills, and it was found eligible bills, thereafter within 6 weeks, the amount shall be paid. But now what has been done, they directed the authorities to take a decision. That is not compliance. So those kind of.
Oh, let them face then.
Yes, the officer is present.
2 weeks. Stop. If by the said date, this court's order is not fully complied with, the court will presume that the violation of the court's order is intentional, warranting exercise of contempt jurisdiction by imposing appropriate punishment.
At 496.
Yes.
In this case, Malon, you have last an order. 2024.
496 value after launch value. 496 value.
What?
Control value.
What do you want?
After launch value.
Why?
After.
Are you not well?
Fine.
All right, 1 week. 1 week. It seems you are not well. What happened? Sorry.
After notes, my lord.
All right, we will take up, the case will be taken up next week.
Yes.
को पानी दो. Yes.
These are the matters on the procedural matters. That's the old matter. Item 64. Old matter. Item number 64.
You actually
64. Yeah, please watch it. Not this manner.
Not good.
Grateful.
Item 65.
Compliant, my lord. Compliant.
Not pressed.
Complied.
Complied.
Item 66.
Pardon to appear in the BC, Your Lordship. Item number 66, I have no instruction.
No instruction.
67.
Become infectious manner.
Item 68.
It has to go again, my lord. Item 68, notice has to go again, my lord.
No, whether order has been complied with or not.
Order has not been complied. It's a violation of Lordship, it's a contempt arising out of a second appeal. Order is at annexure 1. There is a status quo order. The contempt has violated the order. And notice was issued on 13th 2019. Notice was is not yet sufficient.
Where is the order?
Annexure 1, page 7, my lord. Page 9 is the order, my lord. As an interim parties are directed to maintain status quo with regard to suit scheduled property till next date of listing.
This matter be listed along with that appeal is pending.
The appeal is pending, my lord.
RSN number 113 of 2016. No. Oh, before the assignment.
Item 69.
One appears. Citizen for default.
Item 70.
Seven.
71.
Let's see, item 71 and 72, let's compare.
Complied with.
73.
Non-compliance order dated 30 December 2016, my lord. There is an interim order passed for stay of the under annexure 4, but subsequently that has not been complied, but the opposite party authority under annexure 2 passed an order of re-engagement of another person.
we are disengaged, but that has been stayed. But subsequently, the authority engage another person for the same post.
But your this thing, your disengagement was stayed,
Your lordship.
but you have
But you are not been able to continue in this said post, but the authority engagement letter for another 2%.
Where
Can
is the
you
order?
and I page 12 annexure to my lord.
And where is the order of this court?
Order was 30 December 2016, my lord.
Sir, some order has been violated.
Yes.
Where is that order?
That is the 30 December 2016, my lord.
You have not annexed,
That has not been annexed.
neither quoted nor annexed.
That is, but subsequent to the interim order passed, I am annexed the annexure 1 series, page 9, my lord. That is 12/1/2017. That is to continue. But subsequently, we filed the retention and that has been acknowledgement.
Where, how can you see the interim order? You are alleging disobedience of an order. You have not annexed that order. And how can you make that is contempt application? Yes, so where is the interim order?
Can you see the certified copy of the order?
What is your case? Where is this order? 23/12/2016?
Your lordship.
Where is that order?
That is the on the 30 December 2016, the interim orders were passed. For stay the interim order under section 4 in the read petition.
Where is that order? Order dated 23/12/2016.
That has not been annexed.
Then we will not. The petitioner has alleged disobedience of an interim order of this court dated so and so, passed in WPC number so and so. So by the said order, comma, an order passed on a communication dated 23/12/2016.
30 December 2016.
23/12/2016 was directed to be stayed. First off, neither the said order dated 23/12/2016 has been brought on record, nor the court's interim order has been brought on record. So this is one aspect of the matter. First off, next, secondly, comma, the petitioner filed the contempt application alleging disobedience or filed the further it has been specifically stated in the so-called affidavit filed on behalf of opposite party number 1 that the petitioner was not an employee of the corporation. Which corporation?
Odisha State Civil Supplies Corporation.
Orissa State Civil Supplies Corporation. Rather, he was engaged by Messrs. Bharat Security Service Panikoli of Jaipur district as service, which was the service providing agency. First off, the petitioner deployed as manpower by the service provider cannot claim, does not have any, cannot claim any relationship of employer and employee, comma, it has been asserted. So stop. Next, in my considered view, this contempt application is totally misconceived and stands disposed of accordingly. Yes.
74. Okay.
Order has been complied with as stated by Land Council for the contender.
75.
That violation of which has complied with.
I will oblige if lordship call this matter next week
Why, madam?
because I am handicapped, my file is
All
missing.
right. Next week.
76.
Oblige.
76, your lordship, I will seek instruction from the petitioner in this matter, whether all the order has been complied to the full extent. It was actually in the judgment, it was directed that to release the consequential benefits of the pay scale with the payment of UGC scale of pay with effect from 1/1/1986, your lordship. So I'll seek instruction on that.
So who is for the other side? And where is the order?
Your lordship, that is in disposed of contempt case, it has been the original main judgment is there in the contempt 1497 of 2016. It has been tagged there, your lordship. In the judgment is your lordship annexure 3 of that 2016 contempt. Your lordship.
No, you are alleging violation of which order?
In this contempt, your lordship, actually what happened, initially one contempt was filed. The first contempt was disposed of with the direction to comply with the order within a certain stipulated time, your lordship. Thereafter, they did not comply, so I filed a second contempt, that is 198 of 2017, your lordship.
Last order टा कितने थिला कितने last order एक
Last order, no particularly known. But very much.
As requested on behalf of the petitioner, list this matter on 2 weeks. Published.
Item 77. May I please, your lordship? But this contempt application arises out of the non-compliance of the order dated 17/2/2014 passed by this honorable court. Here, what happened, your lordship, in favor of the petitioner, there is a civil court decree. Civil court decree, which is at annexure 1. The judgment is at annexure 131/8/2004. The right title interest over the suit land was declared in favor of the petitioners. And the judgment is at annexure 1 and annexure 2 is the decree. Thereafter, the petitioners approached the Tahsildar Bhogurai and filed a mutation case. The Tahsildar Bhogurai allowed that mutation case and directed the record to be directed the RR to be corrected in the name of the petitioners. Thereafter, subsequently, your lordship, the Tahsildar so moto reviewed his own order, recalled the order. Sorry.
Tahsildar?
Yes, recalled his own order and said that the decree in the civil court was obtained by practicing fraud. So he recalled his own order, challenging which the appeal was preferred before the sub-collector. Sub-collector also confirmed the order. Thereafter, the petitioners approached this honorable court, and this honorable court had order dated 17/2/2014. If your lordship kindly turns to page 72, order is there, and operative portion of the order, the specific direction is at page 73. Last but 2 paragraphs.
Yes.
The 72 last paragraph is while recalling the order, the Tahsildar remarked passed adverse remarks against the learned civil judge. That this honorable court also found out that this is contemnous. And specifically directed the Tahsildar to remanded the matter back to the Tahsildar and directed to correct the ROR within the purview of the decree.
Yes,
That order ought to have been complied. I'll take instruction with that.
see, according to him, the decree was obtained by fraud.
That has been set aside by the honorable single judge.
The order has been set aside.
Yes, then he has to follow the original order, which he recalled
But
himself.
he could have, since you see, if he was of the view that the decree was obtained by fraud, being an officer, he should have approached the civil court.
Civil court to set aside the decree, to avoid that decree.
He did not do that.
Instead, he himself recalled the order on the.
Even today, he has not done that.
That your lordship may give me 2 weeks' time. I will take the instruction. What is the status?
These are 17 matters.
I will ask him to do it immediately. I will ask him. 2 weeks' time may be granted. This is Tahsildar Bhograi. I will ask him to do it immediately. This is civil matter.
Please tell your officers that if they want to know if they have not known the contempt jurisdiction, I'll make them know. Your officers are taking the court's order too lightly. And I'm gathering an opinion that unless a top officer is convicted of contempt of court, the situation is not going to improve in this state. This is too much. This is 2024 and the order was set aside and this Tahsildar. There is disobedience of,
The direction to.
there is allegation, just a minute, there is
Your lordship will
allegation
take
of-
chance to.
There is
obtain instruction.
allegation of disobedience of this court order dated 17/2/2014, passed in WPC number 22251 of 2023. Stop. 2013. This contempt matter is pending since 2017. Stop. It appears to be an admitted fact that this court's order has not been implemented. Court order dated so and so has not been implemented. Stop. The court takes judicial notice of the fact that in most of the cases, the authorities under the state of Odisha are not giving due regard to the orders which are being passed by this court in different jurisdictions. Stop. This case displays this is a fit case where proceeding for deliberate disobedience of this court's order needs to be initiated. Stop. However, the court will also desire to know from the head of the department of the contemner as to what action is contemplated, what disciplinary action is contemplated under the officers who violate the court's orders, who either violate the court's orders deliberately or ignore such orders passed by this court. ignore the orders passed by this court. First off, such affidavit must be filed in this case by who heads the department?
Revenue Department is Revenue Secretary, yes.
The Revenue Secretary,
Additional Chief Secretary, Revenue and Disaster Management.
Additional Chief Secretary, Revenue and Disaster.
Disaster Management.
2 weeks. First off, list this matter on 2 weeks. When which Tahsildar is in?
Bhogarai.
When President Tahsildar of Bhogarai shall be required to join the court proceeding online.
78 obliged lordship.
That the violation of the order dated 9/10/2015, my lord, that this honorable court has got order of
Interim order.
my lord.
Where is that WPC?
WPC number 18093. This matter is there, my lord.
Still pending.
Still pending, my lord.
So what is that about?
The counter has been filed, but hearing has not been.
What is the writ petition about?
Writ petition regarding cancellation of the letter of intent issued in favor of the petitioner.
Cancellation of
Letter of intent
For?
was issued by the BPCL for installation of a petrol pump, my lord. And this honorable court has granted interim order not to allow the petrol pump without leave of this court, my lord. But the authorities have granted permission to install the petrol pump, and they have also filed their reply to the contempt application. You will also kindly see the show cause reply filed by the contemptor. In paragraph 11, my lord. Paragraph 11, page 4, my lord. What they have stated that on the basis of the letter of intent advertisement, the letter of intent issued in favor of the petitioner, on the basis of that advertisement, they have not allotted the petrol pump in favor of the beneficiary, my lord. But they have stated in respect of another advertisement on dated 7/2/2012, they have allotted, but they have not annexed a single scrap paper regarding the advertisement, when it was issued and which area it was issued, that they have not annexed. Only they have annexed my writ petition to the show cause notice, and they have stated on the basis of a new advertisement, they have allotted, my lord. Because the things has not been done in a direct manner, they have done it in indirect manner, my lord.
So whether you have filed your counter, who is to file counter affidavit in this case? Writ petition counter affidavit has been filed.
Yes, my lord, BPCL has been filed, my lord.
PPCL has filed the counter affidavit.
Petition, they have also filed, and in the contempt application, they have also filed.
Same stand taken in both the cases.
Same time has been taken. In letter of intent, they have stated the acquisition has been made in respect of the mine land. I have not disclosed that land.
I'll decide both the cases. Both the cases, the writ petition and the contempt petition, both the cases shall be decided together. Who is for the other side?
My learned children, Mr. S.D. Das was appearing for the BPCL, my senior advocate.
There is no representation on behalf of the contemptor. So place this case on next Friday. Please inform him.
Yes, they will also keep it matter
1 week.
problem.
So I intend to hear both the cases.
Yes, yes.
Writ petition and contempt
Mal. Okay.
matters.
Bail matters are there, and bail matters are also.
230 arbitration and
2:30, half an hour I'll take up these contempt matters.
Yes, ma'am.
And then
Yes, ma'am.
Because you also argue today, because petitioner retired by 7th July, and judgment was passed directing the opposition to give me regular appointment. So it will not be ordinary, so at the last tribunal taken up, otherwise it control the infectors.
we will take care of it in the next Friday.
मतलब 7 तारिख रिटायर करगले आउ अपॉइंटमेंट चेंज करबे इनफ्रुक्चर समझिबो माय लॉर्ड सो विल रिटायर बाय 7 so they will say retired no appointment
525.
525 so they may
He or she will be retired in 31st July years because date of retirement as per government service is end of the month, not that on that day. Anyway, 5th I am trying to find out, it's with my friend, Ross. If necessary, I will take instruction.
before Rajini, my lord. Before Rajini, so that they will, what instruction they have taken, because along the 21, you will also directly take instruction specifically.
All right, I give you liberty to make a mention on Monday,
Yes, sir.
Tuesday even. In the court, you can make a mention.
Well,
All right,
yes, sir.
and be in touch with him.
Yes, sir.
Be in touch with him, make a mention on Tuesday. Monday, I may not be here.
Tuesday, my lord.
Make a mention on Tuesday.
Offline. Very much offline.
The more received,
High 25.
107, 108, 162, 369, and 474.
Reconciliation is little less than 545 to 549. Also for withdrawal.
525, item number 526 to 529. Item 526 to 529 for withdrawal. Item 79.
I am appealing for the opposite party. The order has been complied with. Order dated non-compliance of order dated 22 February 2016, passed in WPC number 2546 of 2016. But this housing matter of allegation in the contempt matter case that has been already complied with, and the petitioner being agreed by that order has also filed another writ application challenging.
It is stated by learned counsel representing the contender that this court's order has been complied with, and the petitioner agreed by the decision of the corporation.
Yes, ma'am.
Of the corporation has filed a writ petition. This contempt proceeding stands stopped accordingly.
Item number 80.
Item number 18, not close, my lord. And then another two items also, 131 and 160, they have not present.
Item number 80 minutes, I am appealing for the authority.
Complied with.
131, 160.
160, 131, 160.
Item number 81.
Partly complied.
Complied with.
Item 82.
My lordship, notice is that a focus file, we have not solved the copy. Had to be like this, the petitioner is retained person, he is not getting the gratuity, leave salary and other benefits, for which is that direction is issued to dispose the representation, find with the petition.
So whether the representation has been disposed of or not?
Disposed of, still that they have not disposed.
Representation has not been disposed.
Yeah, not disposed. I will, this is the second content. And till date, he is not getting his gratuity and leave salary and other benefits.
The representation has been disposed of.
My lord.
Your representation has been disposed of. What else?
They have not communicated.
It is there.
Not the copy, my lord. So
No, it is already there in the so-called affidavit.
no, I have not received the copy, my lord. That is, I have not received the copy.
Copy is there with who is for the other side?
How can I know whether they have disposed of or not? This is the second
It
copy.
is there. It is there in
They
the
have,
so-called.
they are supposed to solve the copy on me. They have not.
Let the registry serve a copy of the so-called affidavit filed on behalf of the contender. From the so-called affidavit filed on behalf of the contender, it is apparent that this court's order has been complied with in as much as the petitioner's representation has been disposed of. From be that as it may, this case on. Next week.
Item 83
No,
87. 87.
83 same. Item 84.
My lord, the petitioner does not want to close this application.
yes, does not want. And what about writ petition? Writ petition? Writ petition you are not present.
Both.
Item 85.
My lords, item 85, I am on VC for opposite parties. We have complied with the order of the Honorable Court.
Thank you.
Item 86.
English two interim orders, two contempt orders. Those orders are not complied with. For the meantime, there is some technical difference in the council for the Soro municipality, he has died. Also, his that bill has been transferred to anybody or not. My opponent is not before me. My opponent is not before me since Mr. Sahni was died. Whether that bill has been realized by anybody or not, that is the he is appearing as one of the contempt orders, not for municipality.
What was the order?
Order was my fact contempt was
Writ petition is still pending.
writ petition is still pending.
All right, the WPC number so and so be listed before the assigned bench with the present contempt matters, which arise out of interim orders passed in the said case. Yes,
So that's why I expedited that writ petition matter will be taken out.
yes.
Item 87. Item 87.
On appears
88.
87 is also complied with.
88 no instruction. No, 88.
88.
88.
88 no instruction. No instruction, my lord.
No, it's 87. 87. DGA states that the order is compliant. There is no representation on behalf of the contempt civil stands dropped accordingly.
Item 89.
On behalf of dear Nanda, my lord, she has not filed with her, my lord. So 1 week time, my lord.
As requested 1 week.
Item 90.
Yes. There is no representation on behalf of the petitioner. So it appears from the so-called notice, so-called affidavit which has been filed.
I have obtained instruction that order has been carried out by the officer concerned. He has given me instruction since 19/6/2017 that order of lawsuit has already been complied with in matter of spirit law.
As substantial, that there is substantial compliance of this court order. And no case of deliberate disobedience of this court order is made out. Contempt sitting stands dropped accordingly.
All three cases.
Right.
Item 91.
On appears. Yes.
95.
No appears.
96.
Yes.
Item 97.
No instruction.
No instructions.
Item 98.
No instruction.
No instructions.
Item 99.
Item 99, my lords, infractions.
Instructions.
Let's another item 141, my lords, that is also infractions.
141.
Item 100.
My lords, I pray for the next list because my lord said the hour you got the list. I could not place the file.
All right.
100, I have item 100 my lord, I am appealing for the contempt. Already complied with and the so was filed in 2017. All complied.
Next list it will come.
All right, we will take up next week. And see, the council is saying therefore the court has no other option but to.
We have filed in the so was in 2017 both for Q1 and 2. And said that already complied with
All
this.
right.
That is the old area amount.
All. Yes. We'll see next week.
101.
Usually the government of India might have the party.
So 101 order has been complied with.
There's no representation. Hold on.
Item 102.
Yes. On appears on behalf of the petitioner. Interferes.
From 102, they said there is a violation of the interim order. Plus, the affidavit has complaint will be filed by the also deputy commissioner, so also the Tahsildar both since 2017. And REIT must have been disposed of by now, that's why nobody is appearing in this case. Item 103. Item 104.
May I please you also? In this case, my lord, I have instruction to appear. The lordship's order dated 12/12/2016, page 7 of the writ petition. Direction was issued to Tahsildar to consider and dispose of the mutation case by giving opportunity. In the meantime, they have not complied the order, my lord. Even though 2016 order was passed, my lord. I have submitted my representation under Annex 2 series at page 8.
Yes, seek instructions.
I will tell you.
2 weeks.
Item 105.
There has been this against for implementation of order on Annex 2 of the writ petition. That is not possible. That has been communicated to the petitioner. I have not filed the so-called of your order.
So it has been complied with.
He approved the appeal party contempt and the appeal party has communicated in the order that it will not be possible to comply the order on Annex 2. To open a door in the northern side is a alert.
Where is the order?
Malak,
Where is this court's order?
order is there at page 10. Order 10, 8,
The decision has been taken.
steps have been taken.
And no contempt.
No.
From the developer. In view of the developments subsequent to the order dated 10/8/2016 in the court's opinion, no case of willful disobedience of this court order is made out. The contempt proceeding is dropped.
Item 106.
Yes. On appeals.
Item 109.
109 miles, I am for the BDA. I'm for the Information Development Authority.
Non-compliance with the order dated 12 under annexure 1. We have complied with or not? Not yet complied.
There's nothing much to, I never glanced to that order, where the order of the cancellation of the permission was very set aside. So permission is restored into file. So the petitioner enjoys this permission, nothing to be complied. Subsequently, what happened, my lords, the petitioner undertook construction in deviation of the permission for which annexure 2 was issued. My learned friend says that is separate cause of action. My learned friend says that in violation of the.
I have a glance at page 15 of the annexure 2. Page 15 or 15. 15 or yes. After the order dated 12/2017 or they have issued this letter on 19/2017 or when where they have directed not to have any deviations, not to have any construction in the settlement.
Yes.
Huh? Not to have any construction about the settlement.
No.
Not to proceed.
No.
Not to proceed. So you are constructing, making construction in violation of approved building plan. So was there any direction that you should make construction in violation of approved building plan?
Exactly.
No, you're not. Then Annexure 9 was passed, then what was annexure 9? Annexure 9 was passed and according to that I am constructing with the building allotment. Thereafter annexure 9, what was annexure 9? Not having the read copy.
Annexure 9 is cancellation order of the permission. That was crossed. The permission is restored into file. Now he was required to undertake construction in consonance with the permission. He report submitted that they are undertaking construction in violation of that permission. That is what the subsequent, that is a subsequent cause of action.
Lordship may give me to next week, Lordship. Let me get all right.
Item number 110.
Obligation.
Item 111.
Wait, please, my lord. My lord, this is the second content, my lord. And my lord, the operative portion is at page 5, my lord.
Where is the order?
At page 5, my lord. On 16/2/16. The order passed on 16/2/16. Page 5, my lord. My lord, in this order, there is a clear direction to settle the land in favor of the petitioner, my lord. In spite of such, my lord, there are. My lord,
Your son there was, I filed a so-called affidavit, you also may kindly look at.
Have you seen the so-called affidavit?
yes, my lord, I have seen the Sokas affidavit. My lord, kindly have a glance to Sokas affidavit at page 2. At page 2, my lord.
Yes.
My lord, at para number 6, they have averred about the OPLE proceedings, which has been settled in favor of the petitioner by OJC number, my lord, by OJC number, which is in the order passed by this honorable court.
No, madam, you are referring to so-called filed by whom? OP number 1 or OP number 2?
Yes, my lord, OP number. This Sokas. number 2, my lord. OP number 2 and 1. Both
You are referring to paragraph 6 of which affidavit?
and an opposite party number 2, so-calls.
What is there in paragraph 6?
My lord, they have averred about one OPLE case number, which has been mentioned as a slipshod manner because this OPLE proceedings has already been settled in favor of the petitioner, which is the subject matter of OJC number, my lord, which is, my lord, can be seen. My associate is OJC, my lord. There it is settled that OPLE proceedings. And the order was passed on 7/11/2001. And this honorable court, after in view of the
Are you alleging violation of this order 16 to 2016?
Yes, my lord.
So what happened in Supreme Court?
My lord, they have not, no notice has been issued to me, and no diary number is also mentioned in the so-called, my lord.
What happened?
The apex court, you have there approved the apex court, that is paragraph 5 years.
Yes.
Your Lordship, the declaration of Samizdat, the order dated 16 to.
What happened? You have not mentioned even the case number.
Means, that is like diary, it's a unique identification number 5745 of 2017 was granted. And thereafter, I have not, no instruction what has happened to that, so-called. And further was because with that appeal.
Let's suppose affidavit to file on behalf of the opposite parties. 2 weeks.
Item 112.
My lord, that is also another contempt is at 400, my lord. Pertaining to
400.
my lord, item number 400.
400.
Item 112.
Yeah, please, yours. Then about order dated 11/4/2017. Wherein this honorable directed to take a decision to the collector Balesar to take a decision. So in this case, my lord, though what irrigation lands are not irrigated, but they have been charged water rents. And certificate proceeding has been issued. Challenging that, we have approved this on
Whether the decision has been taken.
No, decision has been taken, we must may read of the exact instruction. It is a fact that joint verification of areas where canal water was not supplied to the Royal agricultural land has been conducted successfully by the opposite party with irrigation authorities, and joint report has been submitted to the AGM by letter number 39/2017 for initiation of remission proposal for also that water sessions.
The decision.
My lord, kindly see the order dated 11/4/2017. The decision should be taken by the Tahsildar by giving reasons to the opinion arrived at by him. After submission of the report, the Lord and ADM Balesar should take appropriate decision in the matter. No decision, no order has a supplied to us. We are, the revenue authority are threatening to us every season, every financial year. No order has yet been passed, madam. No final order has been passed. Only that.
Difficulty is that the order which should have been passed by us is required to be passed by them.
Final decision taken by the collector. Joint inquiry has been made. So we have been summoned, my lord.
Where is the order? Where is the order? Let me see.
Second paragraph, third paragraph of the order, my lord. In that view of the matter, the rate petition is disposed of directly.
Where is that order?
Well, I have quoted it in my contempt application. Page number 2, paragraph 2. I have quoted the relevant portion, my lord.
What is the order direction?
Direction is, my lord. After submission of the report, my lord, Lord Singer has
Where is the direction? What direction was required to be carried out?
Whether the joint verification should be made.
Where is that? Where is the order requiring someone to do this thing which has not been done? As simple as that.
Whether we have not supplied any orders, we have no order has been ordered.
In High Court. Where is the direction of the High Court?
Another order. Paragraph 3.
What is the direction?
May I please?
Please.
In paragraph 3, my lord, in the view of the matter, the writ petition is disposed of directing Tahsildar Simulia to conduct a joint verification as per the
Where again? Where you are reading where?
order in person, order.
Which page? Order has not been enclosed. Order has not been order has been quoted.
Order is quoted in paragraph 3 of my 3 of contempt petition, my lord. Only relevant person I have quoted, my lord.
Is it 779 of 2017?
Yes, 779, paragraph 2, sorry, paragraph 2, page 2.
Yes, where is the direction?
The petition of Sambal Center, this Honorable Bhai author dated 11/4/17. After hearing the parties are pleased to direct the Tahsildar Simulia, my lord, the relevant person, to conduct a joint verification as per the direction of the law and ADM.
You have quoted the order or not?
Order order of the land ADM is annexed.
No, order of the High Court. The direction portion.
Yes, that is I am reading.
I am not getting.
To conduct, my lord.
Please read paragraph 2. Please read paragraph 2.
Paragraph 2, that petitioner submits that the Honorable Court has its order dated 11/4/17. After hearing parties are pleased to direct the Tahsildar Simulia, the my lord, that is the relevant person.
So that is the order. That is 11/4/2017.
Yes, my lord.
Yes.
The decision has not yet been taken by the Royal Collector Balesar. Though joint verification has been made, but final decision has not yet been passed.
Yes.
Yes, so as per the direction of the lordship, I filed the so-called affidavit at page 12, annexure E. All the persons were called, Tahsildar in their presence a decision was taken. They are signatories to that. There is also on record on 18/8/2017, and there it was decided that in their presence a joint inquiry shall be made. On the basis of the joint inquiry, Tahsildar recommended for me a remission of that water cess in 2017.
Nothing is there.
Nothing is there, means?
And there is no evidence to show that now it is being demanded or repeated proceeding has been there is nothing on
The
record.
decision has been taken, you can challenge the decision if the decision is.
My lord, I am sorry to say, my lord, no decision has been supplied to us.
Whether the so-called affidavit has been served on you or not.
So-called affidavit has been submitted.
So there is no decision, you have not annexed.
Yes, no. Annexure E was page 12 there of the Tahsildar because there is a direction to the Tahsildar. He noticed them, they all appeared and thereafter the decision was taken.
I am sorry to say, final decision should be taken by the law and ADM, by law and collector value, sir. That is the order person, my lord. Last line of the order.
Decision.
Paragraph 2 contempt, this is my paragraph 2, last line of the order.
Second decision.
Yes, that
Decision of the report by law and ADM.
Please.
Well, thereafter the Tahsildar recommended the ADM records for remission.
ADM Balasore has taken decision.
That was not before me, but I will obtain instruction that
2 weeks time is allowed for the contemptuous to state as to whether the ADM Balasore has been taken decision in the light of this court's order dated 11/4/2017 passed in WPC number 4112 of 2017.
Well,
I beg pardon, my lord. And item 532, that is personal appearance, my lord. The case of family pension.
532,
532.
that was not called.
No, my lord.
Where is the personal appearance?
32 car. That mention good.
Someone is here.
Nobody.
Comply it.
Lordship, weeks time to comply with the orders, Your Lordship.
No, whether there was any direction for personal appearance.
Yes, Your Lordship.
94.
Yes, Your Lordship. We posted to Friday, Your Lordship. All the personal appearances have been fixed to Friday. The three other cases of the same secretary, Your Lordship.
All right.
To next
Same officers.
Same officer, Your Lordship. Mrs. Anu Garg.
Additional chief secretary, my lord. Additional chief secretary. Which department?
What resources?
The lawsuit have been pleased to direct her personal appearance to be on the next Friday.
Next Friday.
In 2 cases, the lawsuit already directed.
एक जगह रख देना. Yes. Yes.
Arbitration matters.
Item 593, it's a gradual personal appearance. Item 593, there was no personal appearance, concern. 593. 593.
Next Friday we will take up.
So item 375, the order has been complied with.
375.
Your Lordship, I'm
Complied with.
480.
So item 526, 527, 528 and 529, I finally order, let's say permitted. 526, 527, 528 and 529.
You are doing what?
I finally order my lordship. Let's say permitted.
Already.
That's it. 114 to 120, that should comply.
114 to 120. Different of the order.
Your Lordship, I'm appearing in VC.
My lord, orbit my lord.
Not able to in item 102. I was not able to appear in VC. Your Lordship, we have not received no instructions on this item.
No instructions. 102. That's 102.
Much obliged.
Actually dispose of. I have 140 and 170, 140 and 170, both have become infructuous in lordship.
140.
140 and 170.
Madam Mayor, I want to 149, government has a highly so far, I may be direct will swap the copy so that take up this matter next week, my lord.
Must have been disposed of. 149.
149.
149 not been taken up. Not
Taken up, so you have to swap the copy.
Yes,
Next. Next Friday.
Your Lordship, item 383 has become infructuous, Your Lordship.
83. Therefore, a notice was issued that please give slips or please inform that the cases which have become infructuous. So again, on Friday, all these cases shall be listed. So I request all the members of the bar that please give the list of such cases which has become infructuous so that they can be disposed of.
My lord, item number 385. Order has already been complied with.
385.
May I please your lordship? My lord, 198, item number 198, already complied with. 198.
190.
And my lord, 298 also.
Arbitration matters. Consideration item number 1. Second.
Just a minute. Special list. Special list.
Special.
When should I rise? When should I rise? Yes. Let it be called first.
Item 1.
Appearing for the sole opposite party. The last thing the lawyer directed to file the counsel and find the counsel key files. And serve the copy on the petition.
There is no representation on behalf of the petitioner. Let's this matter on next Friday.
Item number 2. Will please, Your Lordship. Lordship, in this case, the opposite party has appeared and filed an IA opposing the maintainability on the ground that this honorable court doesn't have the territorial jurisdiction. Your Lordship may see the arbitration clause that is at page 31. Page 31, the arbitration clause, only the venue, there is no clause fixing the seat of arbitration. Only it is mentioned that the venue shall be New Delhi. And now I'm filing also some judgments of the Honorable Supreme Court, recent judgments where the Honorable Supreme Court has said just because venue has been fixed to
that is different. Venue will not determine the jurisdiction, but cause of action will surely determine.
That is my submission. That is my submission that venue will not determine the jurisdiction. But they have filed an IA opposing the maintainability on the ground that because venue is mentioned is New Delhi, but that will confirm the jurisdiction on Delhi.
All right, let us see the arbitration clause.
That is at page 31. Page 31, clause 10.2.
Place of arbitration shall be.
Just a minute, just a minute. Yes.
And Your Lordship, in this case, the dispute as the cause of action arises in Orissa. Your Lordship, you see page 86. They have raised the demand on us, which we are disputing, and we wish to adjudicate in the arbitration. In the demand also, they have mentioned that the place.
Where was the agreement entered into?
The agreement was entered into in Delhi, New Delhi.
In Delhi.
Yes, because the respondent is based in Delhi. So
for what?
The agreement with the petitioner availed a loan for setting up some training centers. And the training centers were in different parts of India, but majorly we were setting up training centers in Odisha.
Who granted you loan?
The opposite party.
Opposite party granted you loan. Then
for training centers in various parts of India, including centers in Odisha. Then after COVID, they raised the issue that we were not, because there was a clause for performance. They had granted some incentive to us. So we said that because there were restrictions in Odisha after COVID, we could not perform.
Arbitration cannot be conducted here. He appears to be right. Yes, what judgment you are relying on?
Lordship, only for the purpose of cause of action, if Lordship, page 86.
See, Mr. Counsel, the agreement was between you and him in Delhi.
Lordship.
The dispute relates to repayment of loan, isn't that?
No, you are not repayment of loan. They have not demanded the loan. What they have done now is, they have demanded a fee from me that because I could not perform, because there was a performance clause.
Yes.
It is not, so here they have demanded the demand.
So where is the dispute within the jurisdiction of this court?
Yes.
I should maintain a suit here.
Yes, it is within this jurisdiction. That only for Lordship, page 86.
Yes.
They have made a demand, billing of candidate. They have not asked for the repayment of loan. That is, that
all right.
Billing of candidate, they have made the demand. Page 86.
Yes.
Page 86, if you see, on the right corner, this is a demand which they have raised on me. And on the right corner, original for recipient, invoice 31/3/2024, place of supply Orissa. So here, because there is the dispute has now arisen for the centers in Orissa. So for the Orissa centers, they have made this demand to me. And even in my request, because prior to the invoking the arbitration clause, I made a request for them for mediation. That is also at page 66. I have mentioned the details of my performance in the parts of Orissa, where that in Orissa I could not perform due to these restrictions during COVID, and that is why, and that is my grievance. So that is a lordship page 66. Page 66. So here the dispute arises only for the centers in Odisha. Because I have said centers in also in Jharkhand, Assam, but the dispute has now arisen only for the centers in Odisha, for which
For Assam, you will file in Assam.
No, there's no.
Kerala, you will file in Kerala.
Now there's no.
For Bihar, you will file in Bihar. And for West Bengal, you will file in Calcutta.
No,
and the seat is in Delhi. And because you have the liberty, you are doing business throughout the country. As per your convenience, you will file your.
No, so in this case, the dispute, now the only issue dispute is with regard to centers in Odisha. And in this case, section 42 of the Arbitration Act will also apply, because the section 9 application has also been filed by me before the commercial court, Bhubaneswar. So that is also pending. So that also have, section 42 also clearly says that if there is a pending proceeding and jurisdiction has been conferred in a particular court, then the subsequent petitions will be also filed in that court, section 42. And then that judgment also which I am relying on also refers to section 42. Because here the seat is not fixed, only the venue was fixed as New Delhi.
So what for you are relying on this 42?
Section 42 because I've already there's a section 9 petition under the Arbitration Act which I have filed, and that is pending before the Learned Commercial Court, Bhubaneswar. And section 42, if I will just place, notwithstanding anything contained elsewhere in this part or in any other law for the time being in courts, where with respect to an arbitration agreement, any application under this part has been made in a court, that court alone will have jurisdiction over the arbitral proceedings, and subsequent applications arising out of that agreement and the arbitral proceedings shall be made in that court and in no other court. And then the judgments I'm relying on, these deals with section 42 also, and also that whether the venue will confer jurisdiction. If a lordship has file the compilation of judgments, if lordship has the last judgment, because it refers to the earlier judgments also, if you also see the second last page of the compilation.
Yeah.
The paragraph 41, if you have it is well settled that a judgment is a precedent for the issue. I'm sorry, paragraph 42. I'm sorry. Lordship, paragraph 42.
Yes.
It can never be an absolute general proposition of law that where an arbitration agreement says that the place of arbitration is Faridabad, Delhi, and proceedings under part 1 of the Act are also validly initiated in Faridabad, the court in Faridabad would notwithstanding section 42 lose its jurisdiction just because arbitration is later conducted in Delhi.
This is entirely different. Here is a question of appointment of an arbitrator under 11.6.
I'm sorry. Judgment also was for the appointment of arbitrator.
All right.
Because here the Honorable Calcutta High Court had appointed the arbitrator, and the Supreme Court held that just because venue was mentioned in Calcutta does not confer jurisdiction on Calcutta.
It's different. Venue, cause of action, these two things are different.
No, here also in this then subsequently paragraph 46. Paragraph 46, in this case, the development agreement provided that the sittings of the arbitral tribunal would be conducted in Kolkata. As observed above, the parties never agreed to the submitting the jurisdiction of Calcutta High Court in respect of disputes, nor did the parties agree upon Kolkata as a seat of arbitration. Kolkata was only the venue for sitting of arbitral tribunal. Para 47, it is well settled that when two or more courts have jurisdiction to adjudicate disputes arising out of an arbitration agreement, the parties might by agreement decide to refer all disputes to any court.
Have you read paragraph 4?
I'm sorry, Your Lordship, paragraph 46.
Paragraph, in that case, the sitting of the said arbitral tribunal shall be at Calcutta. That was the.
And the petition was filed in Calcutta High Court.
Yes.
Calcutta High Court appointed the arbitrator.
Yes.
Honorable Supreme Court set aside the appointment on the ground that just because venue was fixed in Calcutta, that will not give jurisdiction to the Honorable Calcutta High Court.
Right.
That is and in this case, the venue has been, so just what my humble submission is, just because venue has been fixed to Delhi in this case, it will not confer jurisdiction.
No, because the agreement was also entered into in Delhi. Therefore, the Delhi High Court had the jurisdiction.
My humble submission, agreement being entered in one particular place
should not enter into.
Lordship, paragraph 47 and 48 also.
Yes.
Paragraph 48 also refers to section 42 also.
Yes.
Paragraph 48 also, if Lordship may see.
Yes.
As in this case, the parties, as observed, did not agree to refer the disputes to the jurisdiction of the courts in Calcutta. It was not the intention of the parties that Kolkata should be the seat of arbitration. Kolkata was only intended to be the venue of arbitration sittings. Accordingly, the respondent himself approached the district court at Muzaffarpur and not the court in Calcutta for interim protection under Section 9 of the Arbitration Act. Respondent, having himself invoked the jurisdiction of the district court at Muzaffar, is expelled from contending that the parties had agreed to.
I'll examine. Yes.
But first of all, the post title of the arbitration petition, the address is not within this honorable court's jurisdiction. Now, the registered office here mentioned in Andhra Pradesh, the person who executed sits in Gurgaon, and the Lordship has seen the place of arbitration, parties have agreed. Not the venue, the interplay between the venue, seat, and all these things, not the honorable apex court is clearly held in this case. Lordship. First paragraph itself.
Yes.
But these granted whether the Madras High Court could exercise jurisdiction under Section 11(6) of the Arbitration Conciliation Act 1996, despite the fact that the agreement contains the clause that venue of arbitration Santi Bhubaneswar is the question following to the consideration in this appeal. Paragraph 4, not the clause itself in the agreement is clause 18 of the agreement between the parties contains an arbitration clause which reads that under arbitration shall be under the Indian Arbitration Conciliation Act, the venue of the arbitration shall be Bhubaneswar. There will also kindly come to paragraph 7. The counsel for the appellant submitted that when the parties have agreed for a place, public venue of the arbitration, it gets the status of seat, which is the juridical seat, and therefore only the Orissa High Court will have the jurisdiction over here. The counsel submitted that the Madras High Court urged in assuming the jurisdiction in Section 11(6) of the Act, despite Bhubaneswar being the seat of the arbitration. In this regard, reliance was placed on the Indus Mobile Distribution and the Union of India versus the Hardy Expedition and other judgments. It was contended that the High Court urged in holding the clause 18.
All right. So whether this decision has been considered in subsequent decisions?
Yes, because then that judgment.
Oh, please, I am putting this question to him.
I'm sorry.
Whether this decision of this court has been considered in subsequent decisions.
Now, the Brahmanic, in this judgment will probably not considered, which will then submitted. But this is the. If the Lordship may kindly see paragraph 15, with further clarity there, the Honorable Supreme Court is given in my view.
I have seen.
Paragraph 15.
Yes, I have seen.
Now, they refer on the Swasti gas, which was the three judges bench.
Yes.
They categorically held that when the private parties agreed for a particular venue or the seat of the arbitration, they exclude all other courts. And here also the agreement was executed between the parties in the New Delhi. The institutional arbitration of Indian Council of Arbitration was appointed, the chosen as an arbitrator, and the venue also, the place also.
No, but what about this case, which he is placing reliance on? In case of Raviranjan developers.
The Raviranjan developers will not, the paragraph referred, as observed above, did not agree to refer the disputes. The Honorable Court, the Supreme Court has held that the parties have not agreed to confer the jurisdiction. Because they say that the arbitration will be at some places, where the seat, venue, and the place of arbitration is mentioned categorically in the agreement, that court only shall have the jurisdiction.
No, but that view has not been accepted by the Supreme Court in case of Raviranjan.
No, here the parties have not agreed.
In any case, I'll have to rise. Next week. Next week we will hear you.
Sitting of the said.
Next week we will take up the matter.
God bless you.
Item number arbitration matter next week.
All cases.
Item number 6 and 7, kindly dispose that. I is for neutral is there. Item number 6 and 7.